So I have my Hawaii coffee mug here and I'm ready to talk all things Young v. Hawaii. This was a widely requested video by you guys. It has major implications and I understand why you guys are requesting this because it is a very big case. It really hits at the heart of the Second Amendment as well as it's in the Ninth Circuit, which has impacts for people like us in the state of California. But real quick before we jump into this video, if you think the only license you need to carry a firearm is the Constitution, go ahead and hit that like button and subscribe. Also, I want to give a big shout out to one of the main sponsors of the channel, Franklin Armory. Franklin Armory is an amazing company. They provide amazing products for California residents like the 3AR pistols that they have on the California handgun roster so you can go and purchase from them, as well as they were developing the Title I firearm that they were intending to sell to us but was blocked by the state of California. So Franklin Armory does amazing things, not just for us here in the state of California, but for all other states. They have their binary triggers that people in free states can go and purchase. So Franklin Armory is an amazing company. Go show them support, and I really appreciate them sponsoring this channel. So first, let's jump into some of the factual background of Young v. Hawaii and how this case came up. So Young v. Hawaii, as you can guess from the title, is a case that arose out of the state of Hawaii. And what it has to do with is an individual named George Young was seeking a license to carry a firearm in the state of Hawaii. He sought a license to carry openly and concealed under the Hawaii Revised Statute 134-9, and he sought it from his city police. And he was denied multiple times his license to not only carry concealed, but also a license to carry open. And this case hinges all around the Hawaii Revised Statute 134-9. So 134-9 says, in an exceptional case, when an applicant shows reason to fear injury to an applicant's person or property, the chief of police of the appropriate county may grant a license to an applicant who is a citizen of the United States of the age of 21 years or more, or to a duly accredited official representative of a foreign nation of the age of 21 years or more, to carry a pistol or revolver and ammunition thereof concealed on the person within the county where the license is granted. Where the urgency or the need has been sufficiently indicated, the respective chief of police may grant to an applicant of good moral character who is a citizen of the United States of the age of 21 years or more, is engaged in the protection of life and property and is not prohibited under section 134-7 from the ownership or possession of a firearm, a license to carry a pistol or revolver and ammunition thereof unconcealed on the person within the county where the license is granted. So that's your open carry aspect of that Hawaii statute. So that all sounds good. It sounds like in the state of Hawaii, maybe you could get a concealed weapons permit and maybe you could get an open carry permit as long as you met those exceptional cases proof for the concealed license or maybe the protection of life and property for the open carry. But that is actually not the fact. Mr. Young applied multiple times and was denied both a license to carry concealed and a license to carry open. And factually, what you actually find out is that the state of Hawaii has not issued a concealed license in any capacity, whether concealed or open, in the last 20 years. So not a single permit, either open or concealed, has been issued. Now, there was some discussion of maybe people in their capacity of as a security guard, or of course, police officers could carry weapons openly, could carry concealed, stuff like that maybe. But it was really just these subset of individuals that could potentially get these licenses, but really at large, the state of Hawaii was not issuing permits at all. So although Mr. Young applied multiple times to get his permit to carry concealed or open and was denied multiple times, he then decided to essentially take it the legal route and he filed in a district court in Hawaii. And ultimately what happened is the district court dismissed his case. And the Hawaii District Court dismissed his case based on some procedural things, 12B6 motions, stuff like that. But also they had some determination, some language where they discussed kind of the scrutiny and the constitutionality of Hawaii's Revised Statute 134-9. And what they actually said, the district court said here, is that they would have upheld Hawaii's Revised Statute 134-9 based on intermediate scrutiny. So they said if they would have gotten to the merits of the case, they would have said that intermediate scrutiny applied to 134-9. Now I'm going to have to take you through a really quick course of con law in law school. This is, you do multiple days of classes talking about levels of scrutiny and you go over multiple cases talking about it. So I'm just going to try to dumb it down as much as I can and make it as quick as possible. Pretty much the levels of scrutiny, there's three main ones. There's rational basis, which is the lowest level. Intermediate scrutiny, as you can kind of guess from the wording of it. It's kind of that middle ground. And then there's strict scrutiny, which is the highest bar and the highest standard to meet. And it's the hardest level of scrutiny to pass. So when you're talking about hearing cases about the Second Amendment, and if you're a Second Amendment advocate and you prefer the Second Amendment and you appreciate the Second Amendment, what you want to see is courts applying strict scrutiny to the government's restriction on whatever firearm, mechanism, magazines, open or concealed carry, whatever case they're hearing. You want to see the court applying strict scrutiny because that is the highest standard, and it's really hard for the government to prove that their restriction on that Second Amendment right was valid. And so then when you look at strict scrutiny, what the standard for strict scrutiny is that there must be a compelling governmental interest, and the restriction must be narrowly tailored to meet that government interest. So that narrowly tailored pretty much means that you can't just issue some broad restriction. The government can't just say, for example, like we saw recently in Duncan v. Becerra, what that panel said there is a broad ban on all magazines of more than 10 rounds is not narrowly tailored. It is too broad sweeping. It's way too overburdensome on the Constitution, and it does not narrowly fit what you're trying to achieve. So after the district court dismissed, Mr. Young appealed up to the Ninth Circuit. And at this point, he actually got pro bono legal representation. So at this point, he actually got some legal representation. He wasn't doing it pro se anymore on his own. So now this case was really getting some legs, and it was before the Ninth Circuit. And as you are familiar, the Ninth Circuit encompasses people like us here in the state of California. And the main contention to the Ninth Circuit was that Hawaii's enforcement of that revised statute 134-9 violated the Second Amendment by them restricting an individual's ability to carry concealed or carry open, burdened the Second Amendment, and actually violated the Second Amendment. So that was the main argument going to the Ninth Circuit. And so ultimately what happened in this case is the opinion by this three-judge panel was deeply rooted in the historical and textual context of the Second Amendment. And it very much reads a la Justice Scalia, textualist, originalist. That is really what they looked at. They looked at the historical significance of the Second Amendment, of texts of the time, either leading up before the Constitution was written, the Bill of Rights, the Second Amendment. They read things following the actual writing of the Second Amendment. They followed some things that were said during the Civil War. They really went deep into the historical context of what the Second Amendment means. And so I'll put a link down below to the opinion if you want to read the opinion by the three-judge panel. But first and foremost, what they do is they say essentially that the Ninth Circuit's precedent on things about carrying in public essentially established that concealed carry is not protected by the Second Amendment. The Peruta case, as I'm sure a lot of you are familiar with, essentially said that the Second Amendment does not extend to an individual's right to concealed carry in public. But what they did say is that Peruta did not close the door or essentially establish that an individual does not have a right to carry open out in public, because Peruta dealt specifically with an individual's right to concealed carry in public. And so what the court actually says, and I'll read it for you, is said, therefore the issue became in Young whether the Second Amendment encompasses a right to carry firearms openly in public for self-defense. So that is completely what is at issue in Young v. Hawaii. And so the reason why it's such an important question and why they really had to dig into the history and determine whether there is a right to carry open in public under the Second Amendment is because that determines the level of scrutiny that is going to be applied for the Hawaii restriction and that statute 134-9. And so what the panel discussed when they said when we're evaluating these constitutional cases, and specifically Second Amendment cases, it's kind of this two-step process. And you've actually seen this discussed in other Ninth Circuit cases like Duncan v. Becerra. They say it's kind of this two-step process. Really what they ask themselves first is whether the law imposes a severe restriction on a core right of the amendment that amounts to a destruction of that right. And ultimately what they say is that if it does strike at a core right, if it does destroy that core right, then pretty much it would fail under any level of scrutiny, whether strict, intermediate, or rational basis. They would never apply rational basis, but it would fail under both strict scrutiny and intermediate scrutiny. So really here the court is having to grapple with this question of whether an individual's right to carry openly in public is protected by the Second Amendment, because that is the whole linchpin of determining the level of scrutiny and whether this restriction is valid or not. And from what I gathered from their opinion, and they're kind of grappling with McDonald and Heller and the historical context about the issue of to keep and to bear arms, is what they believe is that Heller and McDonald dealt specifically with self-defense, but self-defense within the home. And they believe that is encompassed by that aspect of to keep. They believe that language to keep was historically meant for an individual's right to have firearms within their homes for self-defense. And so they believed that Heller and McDonald addressed that specific issue. But they kind of didn't address that second part of that coin, or that other side of the coin, which is to bear. And in their eyes, to bear essentially extends to an individual's right to wear a firearm, and not only to wear a firearm, but to wear out in public. So it's kind of that second aspect. To keep deals with an individual's right to have self-defense within the home, and to bear deals with that other side of the coin where it's an individual's right to protect themselves for self-defense out in public. So it's kind of the same coin but different sides. In home, in your area for self-defense, and then to bear is outside in public for self-defense. So that's kind of what I gathered from how they were arguing this. And so, like I mentioned, they pulled from a lot of historical contexts for this specific argument that they were making. And I actually pulled some interesting ones that I enjoyed. They cited George Tucker, who was a legal scholar of the time around the Second Amendment being written. And they quoted him, and he said at one point that in many parts of the U.S., a man no more thinks of going out of his home on any occasion without his rifle or musket in his hand than a European fine gentleman without his sword by his side. So essentially what they're saying is this individual right of an individual taking their firearm and taking it out into public is deeply rooted within the core of what America is and what we as individuals are doing or did at the time. The panel does a good job kind of just summarizing at the end of all the lengthy historical arguments. Essentially what they say is the important founding era treaties, the probative 19th Circuit case law, the post-Civil War legislative scenes each reveal a single American voice. The right to bear arms must include, at the least, the right to carry a firearm openly for self-defense. So what they're saying is, when we look at the historical context, at all these different points of time within American history, they all point to one thing: an individual's right to have firearms, to take them outside in public for self-defense. That is the conclusion that they are coming to. And so ultimately, that is actually what Hawaii comes to, is that they say that the revised statute 134-9 does strike at a core right and therefore is subject to higher scrutiny, but actually they don't even get that far. They then look at whether the revised statute essentially destroys that right. And if it destroys that right, it fails under any scrutiny. It doesn't even matter. They don't even really need to get into looking at strict scrutiny, intermediate scrutiny, or what type of level of scrutiny is applied. And ultimately what they determine is that this revised statute in Hawaii does in fact destroy that individual right of an individual to take that firearm out into public. And so ultimately what they find in their opinion is that Young has indeed stated a claim that section 134-9, its limitations on the issuance of open carry license violates the Second Amendment. And then essentially they reverse the county's orders, they dismiss the state's requests, and then they remand to the district court to actually issue an order according to the opinion that they just wrote. So pretty much it was a win in favor of the Second Amendment rights of an individual. As many of you in the state of California are aware, just because we get a 3-judge panel opinion does not mean that that is going to stick. Essentially what happened then is that it was sought for a rehearing en banc. And there was an order on February 8th, 2019 to actually take up a rehearing en banc. Now, February 8th, 2019, we are now in August of 2020. So why has there not been a hearing en banc yet? And that is because the Ninth Circuit actually put this case on hold pending a resolution in another case that was before the Supreme Court in the New York State Rifle and Pistol Association v. the state of New York. Ultimately, what the Ninth Circuit said is we're going to put this case on hold. We're going to see what the Supreme Court says about the Second Amendment in that specific case. And ultimately what happened in that case is the Supreme Court kicked it, finding that the issue was moot because the New York State had actually changed their legislation after the case arose, changing some of the laws, and essentially in the Supreme Court's opinion, that issue became moot, and so it was kicked. So we really didn't get any opinion from the Supreme Court like we were waiting for. And so the case was on hold. And so now, since the New York State Rifle and Pistol Association case was kicked for being moot, that means that the Ninth Circuit can continue the hearing, and they kind of took the Young v. Hawaii case off of hold. And now it is scheduled for hearing September 24th, 2020. So we are going to get an en banc decision on this issue of, does an individual have a right to carry openly out in public for self-defense, and is that right guaranteed under the Second Amendment? That is what Young v. Hawaii is all about. I know a lot of my viewers are in the state of California, and there might even be viewers in other states as well. Why is this significant for us here in the state of California? And that's all because if we get a favorable ruling by an en banc panel in the Ninth Circuit, that means that then any state within the Ninth Circuit's jurisdiction can use that ruling as a basis to challenge any other restrictions on open carry in their state. So since the state of California is in the Ninth Circuit, we could use a favorable ruling in Young v. Hawaii to challenge any California state restriction on our right to carry a firearm open in public for self-defense. So for example, we have multiple statutes here in the state of California that restrict an individual's right to carry a firearm open in public. For example, we have California Penal Code 26350, which makes a person guilty of openly carrying an unloaded firearm here in the state under various circumstances. And then we also have California Penal Code 25850, which makes it illegal for a person to carry a loaded firearm in public. So we have restrictions here in the state of California that restrict an individual's right to carry a firearm open in public for self-defense. This does not mean that the ruling is just limited to the circuit. Other circuits and other people fighting for Second Amendment rights in other circuits could use this decision not as precedent, because it would not be binding precedent on other circuits or other states that sit within other circuits, but they could use it as a linchpin to point in their argument saying, look, the Ninth Circuit said this, that the Second Amendment does cover an individual's right to openly carry in public for self-defense. We have restrictions in this circuit, whatever circuit it would be, the third, second, first, whatever. We have restrictions within this circuit, within this state, within this county, wherever, that inhibit an individual's right to carry a firearm open in public. The Ninth Circuit said that that's unconstitutional, and we are going to argue here that it is also unconstitutional, and we can point to the Ninth Circuit's opinion. So I know that's probably a lot for you guys to digest. If you have any questions, go ahead and write in the comment section. I'll try to answer them to the best of my ability, but this is a very critical case. So if you like this video and you'd like to support the channel, one of the best ways to do that is to join the Patreon page, and I'll put a link to the Patreon page down in the details. And also just like, commenting, subscribing, and make sure you hit the notification bell, because that all helps us spread the word about the Second Amendment, helps these videos reach other people so that they can become educated about the Second Amendment and help us fight for our Second Amendment rights here in the United States. So as always, thanks you guys for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.